Good morning or afternoon or evening whenever you're watching this, WCS students. Hopefully this finds you well. Obviously, we are back to distance learning for these 2 weeks. This is the only lecture that you need to watch this week, so yay! Not too many lectures to watch. Hopefully you understand all of the assignments and everything being expected of you this week from the email that was sent out. And of course, feel free to check Google Classroom. That has up-to-date information. Or email me if you need help as well, of course. I am more than happy to help you out via email or respond in any way that I can. So please reach out. If something's confusing or I wasn't clear about something, please feel free to reach out. As you know, there is a test this Friday, and in that test you will be answering a number of questions. Note that you may have a copy of the Constitution and a copy of the Bill of Rights out and available for you during that test. So that's, different than normal. I don't expect you to have everything about the Constitution memorized, although that would be a good use of your time perhaps at some point in the future. So that is available to you. So keep that in mind. Don't walk into that test without knowing that. Be aware of that. Use it in your study time. Today we're going to actually finish up our discussion of the Constitution. Of course, you have read through the Constitution at length. You hopefully are familiar with it. The fact that Article 1 talks about the legislature, Article 2, the presidency, so on and so forth. If you've forgotten everything about the Constitution, it wouldn't probably hurt to skim it again. Today, though, specifically, we're going to talk about the Bill of Rights. The Bill of Rights, by the way, specifically, has the first 10 amendments to the Constitution. The Bill of Rights, from a historical perspective, was actually probably the first hot-button issue surrounding the Constitution. The chief problem that the Anti-Federalists had with the Constitution was that it didn't do enough, in their opinion, to protect the rights of Americans. And they were worried that legislatures or executives would have tyrannical power and that they would walk all over the rights of the average man. Now, James Madison and his supporters did not believe that that was the case. They said just because the Constitution does not guarantee a right doesn't mean that the right doesn't exist. And by the way, we see this in the language of the 9th and 10th Amendments. Right? This is what Madison believes. However, his opponents said, while you might believe that, Madison, that's all well and good that you say that, but the Constitution doesn't inherently grant any rights. And if this isn't addressed, if this isn't added onto the Constitution, undoubtedly someone will come along and abuse it. And I think while the Anti-Federalists in general, I think, were not correct in most of their ideas, I certainly agree with them in that one. If we have learned nothing else from the history of government, we know that governments almost always abuse their powers in some way, shape, or form. It's almost constant, and it's almost completely predictable that governments will do things like that. So the fact that the Anti-Federalists mentioned this is relevant. Now, in response to this, James Madison and some of his associates decide that they're going to write a Bill of Rights, something that will protect these very rights that the Federalists were concerned about, and they would amend the Constitution. Now, an amendment, from a legal perspective, is a change or an addition to the Constitution. And the Bill of Rights are all additions. They're not modifying what's in the Constitution. They're adding to what's already written down. Now, that is not always true. Amendments like the 12th Amendment, which modified the election process for the president and vice president, that's actually a change. It is an addition, like there are new things in it, but it's really modifying the old language of the Constitution. And so that's possible. It can be a modification of the document. But these first 10 are additions. So we've got the Constitution, then we've got this in addition. And the first 10 are called the Bill of Rights. And they are usually, looked at separately, even though from a legal perspective they have the same weight of law that the rest of the Constitution does. But they are, kind of separate documents. If you go to D.C. to the archives and look at these 3 documents, you would see the Declaration of Independence, the U.S. Constitution, and then the Bill of Rights sitting side by side there in the main archives room. So it is kind of a separate document, even though in reality, it's literally added onto the existing Constitution. So that's important to keep in mind. We're going to talk about all 10 amendments, although we won't spend as much time on all of them. We're not going to spend equal time. There are some amendments like the Third Amendment, which, while important, for the Founding Fathers and important in general. They don't come up very much. In fact, I don't think there's ever been a major legal court case that has involved the Third Amendment, although I did hear actually this year that a National Guard unit wanted to stay in a hotel, and the hotel refused on Third Amendment grounds, although I don't think that the Third Amendment really actually came into play. But anyway, so we're going to spend some more time on certain key amendments, and then we'll just explain and go through briefly other amendments, so just keep that in mind. Also, remember to keep in mind that originally Madison proposed 12 amendments to be in the Bill of Rights, and 2 of those amendments did not pass initially. And so we received 10 amendments, but if we read the Bill of Rights, we actually have the first 12 listed. You've looked at that in one of your worksheets, but be aware of that. Right? Don't get the 12 proposed amendments confused with the 10 actual amendments. Of course, one of the 2 rejected amendments was later passed in the 1990s, the one specifically limiting the amount or the process of senators and representatives raising their own salaries. If they raise their own salaries, they don't come into effect until the next session of Congress. So if you're upset with your senator or representative for voting themselves more money, you can get rid of them, and they can never get the benefit of voting themselves more money. Pretty sound solution. I'm also extremely fond of the other amendment, which still isn't passed and probably won't, but it hard-capped the population necessary for a new representative at 50,000. So for every 50,000 people, you would have a new representative, which I think would be much more fair. You would be much more likely to have a representative for you. You know, if he only had to represent 50,000 people, that would be better. But unfortunately, that's not the case. And again, I don't think there's a lot of political will to change that, even though I think it is a great amendment. Didn't make it in. No, we are instead going to spend our time talking about the amendments that did make it in, the rights that you as an American have. These are, in general, your most important rights. The only other amendments, in my opinion, that equal the status of the first 10 are perhaps the 13th, 14th, 15th Amendments. These are the Civil Rights Amendments. Crucial amendments that are very important. We also have the 19th Amendment, which guarantees, or the 20th Amendment, which guarantees women the right to vote. Obviously, crucial as well. So there are a few other amendments that are equal in stature, perhaps, to these first 10. But most of the ones that you interact with on a daily basis are going to be these first 10, and they are crucial. Let's go ahead and start with the First Amendment, which in many people's opinion is first not only in number, but it's also first in importance. It reads this way, and by the way, if you want to, I would recommend pulling up a copy of the Bill of Rights on your computer screen there while you're listening to me so you can read along, because constitutional language can be confusing sometimes. It probably will help to read along as I speak. But the text of the First Amendment is as follows. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. All right, so the First Amendment is a big deal. There are 2 key rights that come along with the First Amendment. There's the freedom of speech, and there's freedom of religion. Okay, and let's deal with them in that order. We'll talk about freedom of speech, then we'll talk about freedom of religion. The radical thing that the United States did that really set it apart from all other countries, all other governments at the time that this document was created, is the right of Americans to freely express themselves. Now, I want to caution you to think through what freedom of speech really means. The freedom of speech doesn't literally mean you can say whatever you want at any time for any reason. There are restrictions, right? You don't have the right to cause harm through your speech. And you might wonder, you might think back to that old elementary school proverb, sticks and stones may break my bones, but words will never hurt me. Well, number one, we know psychologically that's not true. Most people would choose to be whacked with a stick than get bullied. So not true. But in addition to that, words actually can cause real physical harm. The most famous constitutional example of this is the situation of the word fire being yelled out in a crowded theater, right? And people stampede for the exits, and in so doing cause physical damage to each other or kill each other, smother each other to death. And if there wasn't actually a fire and you screamed fire in the middle of a theater and caused harm, that is not a protected right under the First Amendment. You can't cause harm, direct physical harm with your speech. That's not allowed. Maybe a better example for us today would be yelling bomb in the airport, right? I mean, that would cause mass panic. That would cause potential harm to a number of people. That's not protected by your freedom of speech. You're also not allowed to be excessively, vulgar either. I mean, there are levels of offensiveness which are deemed not protected by the freedom of speech. Now, you, of course, are allowed to express yourself freely in certain contexts, but you can't, run around naked in the middle of your local town. You could say, I'm expressing my freedom of expression, my freedom of speech, but that's not covered by this either. Okay, so don't take this to be like carte blanche. You can do whatever you want. Right? It's a blank check. I can do whatever I want speech-wise. Oh, okay, it's not quite that. But in general, the government does not have the right to restrict your freedom of expression. Right? You can get onto your blog on the internet and you can write incredibly critical things about the United States, and the United States cannot prosecute you or jail you for those words. You are allowed to express yourself freely. You're able to talk about whatever concepts you want, whatever people you want, whatever government institutions you want, and you are able to freely criticize those people. And by doing this, the exchange of ideas occurs. And the founders were big believers in kind of a free marketplace of ideas. Right? The founders didn't believe that every expression and every idea was equally valuable. Okay, don't think that they're postmodernists where everything's subjective and anything that's said is worthwhile. That's not what the founders were saying. But the founders' ideas were that if you have something to say and you go say it, if there's value to what you've said, if there's relevance to what you said, other people will hear this and they will, respond and they will develop on what you have to say, right? And the good ideas will rise to the top, and they'll be latched onto, and the bad ideas will be ignored and eliminated, and we won't deal with those because people are intelligent, right? They can filter good ideas from bad ideas. That's the point, right? So freedom of speech is a key American value. It's what makes democracy work. Nothing is sacrosanct. You can criticize anything. Unfortunately, there have been times in U.S. history where the government has attempted to curtail the freedom of speech, most famously in the Alien and Sedition Act under John Adams, and again in the Espionage Act during World War I. But these are really low points, and most people agree that the president that passed those rules was in the wrong. So that's the freedom of speech. Incredibly important, and there's tons more nuance to that, by the way. I'm not a constitutional scholar. I'm not a constitutional lawyer. There is incredible depth to the freedom of speech and how it's applied in court cases. And if you're curious about that, well, you'll just have to come back when we talk about the Supreme Court and how it dealt with important court cases that deal with that issue. Now, we also have another right. I mean, we've been talking about this for 5 minutes now, at least, but there's another right in the First Amendment. And that is what we oftentimes call the freedom of religion. And this is perhaps one that we need to think about a little critically because our culture at large interprets this, I think, differently than how it was intended. So the average reader of the Constitution today interprets this to say that religion and government ought to have nothing to do with each other. Right? That's how it's typically interpreted, meaning that the government has no right to tell you what you need to believe religiously, but you as a religious person have no right to bring your religion into the government. That's how most people view that. I don't think that that's what the text says, right? Specifically, Congress shall make no law respecting an establishment of religion. So the protection is really one way. You, as a religious person in the United States, you absolutely are protected from the government. The government cannot intervene and say, no, you can't believe that. No, you have to worship this way, right? The U.S. government can't do that. But nowhere in the First Amendment does it say that you, as a religious person, cannot bring your religious ideas to the government. Right now, if you happen to control the government and you're all of one religious background, that doesn't mean that you can control everybody else because of your religion. But you can bring religion into the government. If you are a Christian, you can use the Bible and biblical reasoning to make decisions. Right? You just can't hold other people to laws just because the Bible says so, right? So there's this subtle difference between, I think, how it was intended and how hopefully as a religious person you would interpret this and how the government normally interprets this. So that's something to keep in mind. And by the way, just being a religion does not give you total freedom to do whatever you want. Okay, the government does step in and say certain practices are not allowed. For example, you can't actually go out and marry a bunch of different people, right? The government actually forbids that, right? Polygamy is illegal, can't be done. So the government doesn't just say, oh, you do that for religious reasons, that's good, right? You can't become like a pagan and sacrifice people. You say, well, this is my religion. I have the right to practice my religion. No, I mean, there are things that the government can do to stop you, right? You can't do immoral actions in the name of religion. But you do have the ability to practice your religion, especially an actually established religion. You pretty much have the rights to practice that religion, and the government cannot intervene and tell you exactly how you have to practice your religion. That's really what the First Amendment is guaranteeing specifically. All right, let's move on, mostly because of time, not because we've exhausted what we could talk about in the First Amendment. It's big, it's important, but we have to move on at some point. Let's talk about the Second Amendment. The Second Amendment reads this way: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is sometimes paraphrased as the right to bear arms. The key, by the way, the reason that this is contentious is the definition of two words. Number one, the definition of the word militia, and number two, the definition of the word arms. And let's break that down by the words. So some people maintain that this amendment specifically gives people the right to form militias, and if you have formed a militia, that militia may have arms, and in that capacity you may have arms. I don't think that's what is intended, but that's how some people interpret it. The other interpretation is that in order for there to be militias, everyone should have the right to possess weapons, right? And that's how I interpret it. That's how historically the Supreme Court has interpreted it. That's how most people view it. But there is kind of a debate over that term. The other question is, what does the Constitution mean by arms? Some people have tried to say that the Founding Fathers only envisioned the weapons that they themselves had access to. So you can own swords and flintlock weapons, but anything of a modern variety that can fire quickly and long distance, they didn't intend. Well, I think that is a very narrow interpretation of the Constitution. Certainly, I don't think George Washington had in mind a modern artillery piece when he participated in writing the Constitution. But at the same time, I don't think he expected the state of military technology to remain the same. So some people have a very narrow definition of arms. It's only what the founders had. I disagree, personally. I think it means any firearm, any weapon. Of course, the federal government and the courts have kind of gone back and forth on exactly the definition of this word, right? Currently in the United States, it is difficult, although not impossible, to buy automatic firearms that fire, for as long as you hold down the trigger and they have ammunition in their magazines. That's difficult. You have to have special licensure, and you can't own firearms that have been produced since 1989 that are fully automatic. So there are certain rules limiting your ability to own arms. You can't own a personal nuclear weapon. And by the way, I tend to agree with the government that there should be some restriction. I don't really want my neighbor hunting deer with a rocket launcher and blowing them up, just because if he misses, he could do a lot of damage with that. So I think there is some common sense restriction that can be put in place. However, I do think that when it comes to actual normal gunpowder weapons, no matter how advanced, the founders would be shocked that they were restricted in any way. That's my personal opinion. But in general, this is a big deal. Here in Michigan, we have very relaxed gun rules. But typically, as you get to more democratic-leaning areas, you tend to have more restrictive gun rules. California is kind of the poster child of restrictive gun laws. And actually, California is at the point where its gun laws are really starting to get up there in federal court. Federal courts are saying you're restricting the Second Amendment right. There's court battles going on, and some of them are still ongoing, so I can't even comment on how those are going to go. But if you're interested, if you're very interested in firearms, you should look into those court battles and see what's going on there and what's being allowed. In general, though, the purpose of this amendment was to enable another American Revolution, right? The point of the Founding Fathers is that if it becomes necessary to dissolve the current government, just like they had done in the Declaration of Independence, the revolution needs weaponry. And you don't want the state to have what's called a monopoly on violence, meaning the state is the only one with weapons, right? That's the idea here, that you want the average person to be able to resist a tyrannical government. And whether we could do that today or not is also a hot-button issue. Can anybody really resist the U.S. government? It's a good question. But that's one that has to be asked. Now, Third Amendment, this is the first one we won't spend much time on. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. In other words, you have basically the right over your own home. The government cannot send soldiers in free of room and board at all during peacetime. And in wartime, the legislature has to pass laws that clearly lay out how this can be done. I'm not sure that the U.S. has ever done this. The U.S. quickly grew in prosperity and wealth, and they had no need to quarter their soldiers in independent people's homes. They could build barracks and bases for those soldiers. So this does not come up very often. But it was a problem before the Revolutionary War. It was problematic for the Revolutionary War. It caused issues and was one of the key, striking points, fighting points between the U.S. and Great Britain. So that is important to keep in mind. Now, let's talk about the Fourth Amendment, which says this: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized. Now that probably strikes you as kind of old-timey language, but the Fourth Amendment is actually really important. Specifically, it requires the government to have a warrant to search your property and a warrant for your arrest and your search, right? And it specifically establishes the requirements to get those warrants, and those warrants are probable cause. Now, as far as your arrest and your search, that is typically left up to police officers who might have probable cause. If you were just walking away from a dead body on the pavement, the cop could reasonably say, this person was walking directly away from a crime. I have probable cause to assume they have a weapon. I'm going to check them for a weapon to see if they committed the crime. If you do have a weapon, you are now a suspect in the murder. If you don't have a weapon, right there, you did not commit the murder, but there was probable cause to search you, right? You might have committed the murder. That's what probable cause means. This person may have, based on clear demonstrable evidence, may have participated in this crime. But this is particularly important when it comes to property, right? The police do not have the right to kick your door down and look around your house at any time they want, right? They suspect you of growing marijuana. They don't have the right to just kick your door down and come look for it. They actually have to have clearly documented reasons to do so. And when I say clearly documented, they have to be able to go to a judge and say, we've got evidence A, B, and C that this is going on, and we would like to go in and look for A, B, and C. And then the judge actually writes them a warrant because of A, B, and C. The police are going in to look for this, and the police can go in. Now, once the warrant is acquired, if another crime happens to be in progress when they're in there, that's okay. But the crime they went in for has to be occurring, or there has to be some reasonable or probable chance of it occurring. Otherwise, it doesn't count. So sometimes the Fourth Amendment comes up a lot in people getting caught red-handed, and then it turns out that the police falsified their evidence on getting the warrant, and a person that is clearly guilty gets to walk free because the warrant got messed up in the first place, right? And perhaps if you're a law-abiding citizen, that kind of gets your neck hair up a little bit. You're like, what? How can a guilty person walk free? But remember that the American system is designed to allow innocent or guilty people to go innocent because we always want to avoid putting an innocent person in prison, right? Benjamin Franklin said, I would rather that 10 guilty men walk free than one innocent man go to prison. So if the warrant gets messed up, then, right, it's like, nope, can't arrest that person even though we found them red-handed doing something. We weren't allowed to be there. We can't admit this as evidence. Case dismissed, right? So this is important. It's an important protection, right? I mean, the British could just kick your door down and find something that they declared illegal, and they could drag you to jail, and there was nothing you could do about it. This protects your personal property. This protects your person unless you are actively doing wrong or doing something that could be interpreted as you doing wrong. This gives you protection. So it's important. Again, there's tons more to say about this. I don't have time, unfortunately. But the Fourth Amendment, pretty important. Fifth Amendment says this: no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Oof, man, there is a lot of important law in the Fifth Amendment. Tons of important things in here. We are going to literally hit them and keep moving because we don't have time to stop, but we will try. All right, first off, this is how you have the right to a jury trial. In pretty much any major crime, you have the right to ask for a jury. Now, we'll talk more about this when we get to the judicial branch. Most crimes, or most cases, I should say, in the United States do not go to trial. They end in plea bargains. A plea bargain is an agreement between the government and yourself for you to admit guilt sometimes and take a penalty, and the government, in exchange for you accepting the penalty, usually gives you a much lighter penalty than you would receive if you went to a jury trial and were declared guilty. You would get a much worse penalty if you did that. That being said, you don't have to take plea bargains. The government has no way of twisting your arm and forcing you to take a plea bargain. They can't do that. You as an American also have the right. You can take a plea bargain. You also have the right to have a judge decide most cases, although there are certain categories of cases, mostly capital crimes, death, murders, rape. But most crimes, you could also have a judge decide. You actually waive your right to a jury trial. You say, I don't want a jury trial. I would like the judge to make a decision. And you might do that because you think that I am definitely guilty, and the judge, if I admit to the judge I'm guilty, he might have mercy on me, and you might do that for that reason. Or you might believe that a jury would be biased against you. Maybe you're an African American that committed a crime in a primarily white neighborhood, and you might say, I think I've got better chances with the judge than the jury. That might happen, although obviously, hopefully you can see that that would be unfair. But there's different reasons that you might choose to have a judge trial, or a bench trial, it's called a bench trial, rather than a jury trial. So that's the first thing in the Fifth Amendment. Moving on, different rules if you're in the military. Okay, it does not apply the same way if you're in the military. If you wonder how that works, you'll have to research that on your own. Not covered in the Bill of Rights itself. Each branch of the military handles that differently. Anyway, that's covered as well. So military is separate. Don't count them. You can't be tried for the exact same offense with the exact same evidence twice. If you are declared innocent and no new information comes up, you cannot be tried again for the same crime. Now, That being said, if you somehow do that, if you commit a crime but get declared innocent, don't call the prosecutor and brag and go, yeah, I really did do the crime, because that's new information. You can be retried, okay? But what this is designed to prevent is a strategy used by the British Crown to lock people up for the same charge multiple times. So let's just say that you're, walking down the street in London and a cart gets overturned and you're accused of stealing some apples, right? And the government really doesn't like you. And so it takes you to trial for stealing these apples. And, you've got proof that you didn't steal the apples, and the jury declares you not guilty. Right? You're innocent, didn't commit the crime. And you walk out, or you're expecting to walk out, and then the government immediately declares that it's trying you for the exact same crime again. And you're thrown back in jail, not prison, right? You're not being punished for a crime, you're being held. But effectively, you are being punished by a government that just wants to punish you. So that's what that is designed specifically to prevent. You can't just be thrown in jail and held for the same crime, especially once you get declared not guilty or innocent. You are free to go. Now, the Fifth Amendment also gives you the right not to testify against yourself. This is oftentimes called the your Miranda rights, or the Miranda warning, which if you've ever watched a police drama, you're probably familiar with this, right? You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have a right to an attorney. That's actually the next amendment. If you cannot afford an attorney, one will be appointed to you, and so on and so forth, right? This basically means that the prosecution cannot compel you to get up, to swear on your truthfulness, and then ask you, did you kill so-and-so, right? You don't have to do that. You don't have to answer that question. You don't have to testify against yourself. Now, that doesn't mean that you can just stay silent. If you are in the presence of your lawyer and you are asked a question, you do have to give answers. You can't just sit there sullenly and refuse to say anything. That actually could be used as evidence against you in a court of law. But you don't have to say anything without counsel. That's actually in the next amendment. And you don't have to testify against yourself. And your lawyer, the purpose of your lawyer consulting with you and being in the room with you is to tell you when you're testifying against yourself, which you don't have to do, and when you're being asked legitimate questions, right? That's the lawyer's job. He's supposed to know when those questions need to be asked. Sometimes this is not done particularly well. Those court-appointed lawyers sometimes are not good. And this has landed several people who probably shouldn't have gone to prison, right? The people assigned to protect them and to know their rights didn't do the best job, and so innocent men and women were sent to prison. So this is a big deal. And I think the United States court system is good about this, but it does sometimes fall through the cracks on this. Finally, so we got all that. You can't be deprived of life, liberty, or property without due process of law. This is called the Due Process Clause. This means that the government has to have a clearly laid out plan for how they're going to deal with your court case. They can't just jail you for 6 years while they figure out what to do with you. They have to charge you with a crime within X amount of time. And if they've charged you with a crime, they have to decide on bail. Or they have to have a hearing to determine if you're not worthy of bail. If you don't know how that works, don't worry. We'll talk about it when we talk about the judicial system. So basically, the government has to have a prescribed way it's going to do things, and it can't just punish you without taking you to trial. This is to protect you from harsh treatment before you are formally convicted of a crime. Because, again, the British government could throw people in jail and leave them to rot and never take them to trial, right? Like, it's kind of like a get out of charging this person for free. If I can throw you in a holding cell and leave you to rot for a few years, I don't ever need to bring a trial against you. I've gotten what I wanted out of it. So that's important as well. Finally, there's a private property clause here. Basically says the government has to pay you if it takes your property. This is a weird law. Like, the government can take can take stuff basically and pay you, and you're like, I don't want the money, I want my stuff, and the government can say too bad, but that's a story for another time. We don't have time to talk about it. All right, Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. This is kind of covered by the Fifth Amendment already. The government can't hold you indefinitely without telling you exactly what's happening. speedy and public, unfortunately, are words that are also highly debated. We don't have time to talk about it. So you have a right to a trial by an impartial jury of the state and district wherein the crime shall have been committed. So the jury is technically of your peers, people in similar walks of life from your local area. The reason that this is important is because people from your area will hopefully have the best understanding of the reasons you did things, right? What drove Caden Stilley to commit the crime? Why did he do what he did? The people that live around you would have the best chance of understanding that. That's the reasoning, and I think that's correct. Which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, you have to be told what you're being charged with, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. All right, so the last three things all relate to your rights at trial. Number one, the government has to inform you of exactly what it's charging you with. No surprises, right? It can't tell you that it's charging you with one thing, then you show up at the trial ready to defend yourself and then switch its ideas, right? You can't do that. It has to tell you exactly what it's charging you with. The American law is very vast at this point, so oftentimes there's multiple criminal charges, right? I mean, someone will kill someone, and if they actually want to go to trial over it, they might bring like 4 different counts of murder against them, different types, and see what'll stick. So the government has to declare all that, so your legal team has the time to prepare how it's going to defend each count. You also have what's called discovery, which means that if either side is going to bring evidence, the other side basically has the right to see that evidence before it's presented in court. And again, this is designed to help the lawyers build the best cases that they can bring. And how discovery works is a story for another time. We'll talk about that when we talk about the judicial branch. But keep that in mind. And of course, we already talked about the assistance of counsel. This is to protect the poor, the common man, right? I mean, big city rich people can hire these incredibly good lawyers, and you, as a country bumpkin, might not be able to afford a lawyer, period. And that is a huge disadvantage, and you could be taken advantage of. And the idea here is that that can't happen. All right, moving on. Almost done. Seventh Amendment, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury unless shall be otherwise reexamined in any court in the United States than according to the rules of the common law. All right, so again, a repetition of the fact that you have a right to a jury. Originally, you had a right to a jury in any crime relating to $20 or more. That interpretation has changed with inflation. If you get sued for $50, the courts won't even admit the case. So you're not gonna get a jury trial for $50. But whatever the minimum that the state sets as the minimum for lawsuits, then yes, you can have a jury trial for that. So just keep that in mind. You basically always get a jury trial, or could. You can ask for one. Finally, in addition to that, jury decisions in some ways are not appealable. So you cannot say the jury found me not guilty. The state can't just go, I want another trial because I think he's guilty. No, can't be done, can't be appealed. What can be appealed are mistakes made during the trial. So if you hear of appeals, right, it seems to go up and up and up the chain. Mistakes are being appealed. Now sometimes those are format mistakes, like a lawyer objected to something and he shouldn't have objected to it, and you lost the case because of that objection. You can appeal that, say this was out of line, this is why we lost the case, the sentence should be overturned. That's admissible. You may also say that I believe that from a constitutional perspective the law was misapplied here. That's a grounds for an appeal, although you have to do certain things to do that. You can't just appeal any case for any reason. A good lawyer knows how to create situations that he can appeal later on and bring it all the way up. And how that works, again, a story for another time when we talk about the judicial branch. Moving on, Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments. inflicted. This provides you two general protections. Number one, bail has to be reasonable, although I have to admit reasonable bail nowadays doesn't seem super reasonable to me. I mean, you hear a lot of times of people with $1 million bails. If you don't know what bail is, don't worry about it. We'll talk about it again. Judicial branch, I feel like a broken record. The government also cannot punish you cruelly and unusually. Cruel and unusual, unfortunately, is a little indistinct. So people interpret this different ways. Some people say that this prohibits the death penalty. Clearly not what the founders intended. They were comfortable with killing people, but how do we kill them? What is cruel and unusual? These are debates that are had, and a story for another time. Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Basically, the Ninth Amendment is a catch-all. If a right is not mentioned here, that does not mean it doesn't exist. Now, it might mean that the federal government tramples all over it, so you might need to put it in, right? And there are 17 additional amendments, so clearly there are some extra rights that we needed or needed to defend. But basically, this is a catch-all, right? This is not an inclusive list. There can be more that are not written down. Finally, 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. In other words, this means that the Constitution can only do what it says it can do. You're probably like, well, duh. That sounds simple. But, it's a little bit more complex than that. But basically what this means is that the Constitution is limited. Right? If the Constitution doesn't talk about it, then in general, what's going to be done has to be determined by somebody else. Right? It can be determined by other laws. It can be determined by your state government. It can be determined by your local government. But if the Constitution doesn't have a power, it cannot. The federal government cannot just act. They have to have some constitutional reason for why they're doing what they're doing. And if they can't find one, they can't do it. That's basically what the 10th Amendment says, in short. All right, I know that was a lot of talking, a lot of information, a lot to wrap our brains around, lots of complex stuff, and lots of legal stuff that we will talk about when we talk about the judicial branch and the Supreme Court. There's a reason that we're going to spend so much time there, because these things are things that will affect you. Hopefully not all of you, hopefully not in every way, hopefully none of you are career criminals or anything like that. But these are things that you will hear about, you might have to deal with at some point in your life. So it's worth our time to spend some time on that. So keep that in mind. We'll talk about more of this stuff when we talk about the judicial branch. Of course, this week you have a test. You already have the study guide. Note that there is a quiz as well, so make sure that you take that. Otherwise, do well on the test, study hard, and remember that you do have access to the Constitution and the Bill of Rights while you take that. Have a great rest of your week.